We are following breaking news out of the Supreme Court. Justices have sided with South Carolina Republicans upholding a redistricting map of a congressional district. It comes after a lower court ruled that the state's GOP-led legislature deliberately discriminated against black voters. So let's dig into this. We want to bring in CBS News legal contributor Jessica Levinson. So, Jessica, this is a district, kind of a coastal district after the census, which happens normally. There is often redistricting once populations move around, but there was some criticism as to how this shaped up, that black voters were shifted out of this district. What did the court decide?
So the court overturned what the lower court, the district court, had said. The district court said here, in this case, when you drew district number 1, you impermissibly used race. And the district court called this, quote, bleaching, moving white voters into a district, pushing black voters out of a district. What the Supreme Court said today is a number of things that are interesting. One, by a 6-3 vote along the typical conservative liberal lines, although there's some fracturing in that 6. By 6-3 vote, they said, lower court, you're wrong, because what we see here is a state legislature that used partisan factors, not racial factors, in order to draw these lines. And what Justice Alito says from the very beginning is using partisanship, using these political factors to draw legislative lines, that's okay. What's not okay is to use race in an impermissible way. And so the majority of the court said, we think it's just what lawmakers always do, drawing district lines in order to maintain and or increase their political power. And so that's the punchline. We can certainly go into the details here, but the punchline is that the Supreme Court, the conservative majority, disagreed with what the lower court said here and said, actually, the lines are fine for District 1.
Let's talk about the makeup here of the opinion. We have Justice Alito writing the majority opinion. Roberts, Gorsuch, Kavanaugh, and Barrett joined him, with Thomas concurring in part. And then on the dissent side, we have Kagan, who wrote the dissenting opinion, and Sotomayor and Jackson, who joined. And in Kagan's dissent, she says, one side you've heard in the majority opinion, the other side you haven't heard, except in the sketchiest of terms, that the state's map makers were experienced and skilled in the use of racial data to draw electoral maps. What are some of the key lines that you took away from the dissent here?
So the key lines for me is that a couple of things happen with the majority, and that's really what the dissent is going after. One, the majority did something fairly unusual where they said, you were wrong, district court, as a matter of factual error. Typically, when the U.S. Supreme Court takes a case, what they say is there's legal error. So here, what the Supreme Court is saying is, you were wrong on the facts, district court, and in doing so, they made it harder for future plaintiffs, for future people challenging these districts on the basis of race, to come forward with a successful racial gerrymandering claim. So the first thing I noticed is the dissent pointing that out, but also pointing out the idea that this undermines the foundation of why we have the Equal Protection Clause, the Voting Rights Act, that there's something undemocratic about being able to draw these types of district lines and to hold elections under these district lines. Now, again, what you really have is two very different views of what racial gerrymandering prohibits or allows, and what a judge's role is in saying to state lawmakers, no, you went too far. I think Alito really wants to leave this to lawmakers hands off. For Kagan and the liberals, they're protecting and upholding individual rights, and they're very comfortable being here with a searching level of judicial review.
So I kind of want to speak in almost kind of like more plain language so people can kind of understand the arguments. And you can correct me if I'm wrong. But as I understand it, the argument was that race was being used as a proxy for partisanship, that, oh, we think black people vote for Democrats, so we're going to move black people into this other district so we can strengthen the Republican vote in this district. And what it sounds like the Supreme Court has concluded, at least the majority, is no, they were just looking at people who generally voted for the Democratic Party, and that was what informed their decision making about how they were going to shape this district.
Is exactly right. I just had this conversation in my class last night about how do you determine what's motivating a government actor, in this case, state lawmakers, when it comes to something where partisan affiliation and race are all mixed up. Because we know that, just based on statistics, we know that certain racial groups are more likely to vote for people of certain partisan affiliations. And what the court said here, Anne Marie, I think you got it exactly right, was what the state lawmakers did is they just used factors that they can use that deal with politics, partisan affiliation. They weren't motivated in an unlawful way by race. They weren't trying to dilute the votes of people on the basis of race. And that's what the majority really came out with today.
Yeah, the majority opinion saying the court starts with the presumption that legislatures act in good faith. But I also want to read just the conclusion of Kagan's dissent, which says, in the electoral sphere, especially where, quote, ugly patterns of pervasive racial discrimination, end quote, have so long governed, we should demand better of ourselves, of our political representatives, and most of all, of this court. Respectfully, I dissent. So, Jessica, when Anne Marie says we want to kind of take a look at the layman's terms of this, the 30,000-foot view here. What does this mean for the 2024 elections? I mean, this is essentially Representative Nancy Mace's seat. It makes it more strengthened as a conservative seat.
Well, that's right. It means that the current congressional maps in South Carolina will stand. Those are the ones that will be used in the 2024 elections. That's what we predicted for a whole host of reasons. And it means more broadly that when state lawmakers draw lines in the future and they say, no, I was really motivated by partisanship. I was motivated by who's going to be likely to be my voters. I wasn't motivated by race, that it will be more difficult to challenge those decisions. Again, not just in South Carolina, but that in other states as well.
So, Jessica, before we let you go, I want to ask you about something else, because this was like the second big gerrymandering case that people were watching. The other one was, we got a decision last week. It was in Louisiana. And so, because I'm not a constitutional law professor, I was trying to see if there was any overlap. The decision in Louisiana was a little confusing for me, because in this case you had the more liberal justices, I think, dissenting, and what they chose to do was to keep a second majority black district. So, I mean, is there any overlapping between these two cases at all? Can you kind of flesh that out?
So there is overlap. I think you're exactly right that the Louisiana case was somewhat confusing. What I would say is that they came up to the Supreme Court in different forms, but I think for people watching at home, if they're thinking about, well, what exactly did the court say in Louisiana? What exactly happened today? My takeaway would be, you might think this is great, you might think it's terrible, but what we have here is a conservative court saying that when it comes to challenging lines on the basis of race, when it comes to making claims that your vote was diluted on the basis of race, that it will be increasingly difficult to do so. And I think one thing to remember, not just in Louisiana, not just in South Carolina, is that back in 2013, this is a Supreme Court that threw out part of the Voting Rights Act, where states like South Carolina and Louisiana had to check in with the federal government before they made changes to their election laws, including changing district boundaries. And so all we have left of the Voting Rights Act is really the portion that we're talking about in terms of prohibiting vote dilution on the basis of race. And what I would say is, I think today we see a court wanting to make it more difficult to bring those types of cases.
All right.
None of us are constitutional lawyers. We so appreciate you being able to jump in front of a camera on such short notice. Jessica Levinson, thank you.
Thank you.